The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to today's webinar. My name is Amanda from CCIQ. I'll be your facilitator for today. Joining us today is Diana, Manager of our International Trade here at CCIQ, and we have a special guest as well, Randeep Singh from DWF Australia. So thank you for everyone for joining us for the fifth webinar in our 7-part series, today's fundamentals on regulatory and legal aspects. Today, Deanna is going to take you through some of the export regulations, followed by Randeep, who will speak about your legal considerations for agency and distribution agreements, as well as direct sales contracts and IP protection and confidential information management. But before we start, if you do have any questions for both Deanna or Randeep, please send this through using the chat box that appears on the bottom right-hand side of your screen. We'll collate these and ask them at the end. So thank you. I'll now hand over to Diana to take you through today's presentation.
Good afternoon, everyone, and welcome to the fifth webinar of our webinar series, The 7 Fundamentals to Export. My name is Diana Georgieva. I'm the Manager of International Trade for the Chamber of Commerce and Industry, Queensland. It gives me a great pleasure to introduce to you today part 5 of our webinar series, The 7 Fundamentals to Exporting. The focus of our discussion today will be on regulatory and legal aspects to consider when preparing for your export venture. Our guest presenter today is Randeep Singh. Randeep is a solicitor in the corporate and commercial team and DWF in Newcastle. Randeep has advised clients in Hong Kong, Malaysia, Singapore, and the United States on a range of international supply chain, customs, and trade matters, including the import and export of military and dual-use items, UN and country-specific sanctions, compliance, efficient navigation of free trade agreements, customs classification and valuation, licensing and rules of origin compliance, in addition to covering other trade law developments in APEC, ASEAN, and the World Trade Organization. Let's get started. I have mentioned in the first 5 webinars, and I'll mention it now, the reason for delivering this webinar series is to assist the Chamber of Commerce and Industry Queensland members and the other SMEs that are not export ready to become export ready. Becoming export ready refers to a point where businesses become equipped with the required knowledge and skills to successfully venture into trading with international markets. CCIQ can assist your business in increasing your knowledge and capabilities in relation to each of these steps so that your business is in the best possible position to succeed in the international arena. To recap the last 4 webinars, in webinar 1, we discussed how to assess your product export capabilities and your company export capabilities. We have concluded that once you have established that you have exportable product, that your company is capable of exporting, that you know your strengths, you can build on and weaknesses to address, then you can move into the next step, which is organizing for exports and identifying opportunities. In webinar 2, we have discussed the importance of market research, desk research, and in-market research to assist you with organizing for your exports and identifying opportunities. In webinar 3, our focus was on market entry strategies options and how to determine which is the right one for your business and for your products. In webinar 4, we discussed marketing and planning considerations. We focused on your export plan and on your export strategy development. And today, the focus will be on regulatory and legal requirements. And this is the agenda for today. I will be covering the regulatory part, and Randeep will be delivering on the legal part of today's presentation. Let's get started with customs and quarantine. There are extensive regulatory requirements enforced by Customs Australian Border Force and Quarantine Biosecurity Department of Agriculture and Water Resources. Customs' primary role for export is to follow strict regulations to ensure Australian goods are correctly processed prior to exporting. Any goods that attract an FOB value of 2,000 Australian dollars require a customs export declaration. Any goods that require a permit, regardless of value, for example, quarantine permit, excise permit, wine and brandy permit, require a customs export declaration. Any goods exported are required to be accurately classified by goods commodity. Customs is also regulated to enforce compliance for the export of restricted or prohibited goods. If the goods are restricted, then an export permit would be required. Without it, an authority to deal export entry will not be granted. A goods cannot be exported. Restricted goods are items such as asbestos. If the goods are prohibited, under no circumstances will the goods be issued an authority to deal export entry and are not allowed to be exported. Goods in this category include many drugs, including prescription drugs, medicines, therapeutical substances, Australian native animals and some plant species, ceramic ware, many chemicals, chemical weapons, firearms and firearms parts, ammunition, and endangered species. Quarantine biosecurity's primary role for Australian export is to adhere to very strict procedures and regulations, partially dictated by foreign countries, and also as a matter of course to protect the good reputation that Australia has built up around the globe for the supply of Australian prescribed goods. Quarantine enforces compliance of all prescribed controlled exports, ensuring that Australian goods are safe for other countries to import. The department has split its goods jurisdiction into the following 8 areas: dairy products, eggs and egg products, fish and fish products, kangaroo meat, live animals, meat and meat products, organic and biodynamic products, and plants products. Ultimately, the responsibility to establish the import requirements of any particular country lies with the foreign country, established through the importer of that country and the presumptions that they would supply the Australian exporter the required conditions to be met to allow border acceptance of the prescribed goods being exported from Australia. Under no circumstances should an export of prescribed goods take place without strict import conditions requirements issued in writing by the importer based on the conditions set by the import country for a particular good. There is a quarantine guide that can be referred to also that outlines if goods are prohibited, require import permit and other specific conditions relevant to a product to the relevant country of export. And that is my core, Manual of Importing Country Requirements. This is a good tool, but just use it strictly as a guide only. As you can see, customs and quarantine is quite a substantial topic. And for additional information on the subject of customs and quarantine, including obtaining the Manual of Importing Country Requirements, please refer to the Department of Agriculture and Water Resources. You can also contact our office for guidance and assistance. In general, governments encourage trade, and the free trade agreements between Australia and other countries and between other countries are a testament for this. However, there are rules and regulations which can act as impediments to export if you don't have a good understanding of those. Let's take the export licenses, for example. Linking to our previous discussion on country conditions and requirements for goods, many overseas governments impose requirements for export licenses for certain categories of goods or goods that intend to be exported to a certain country. In general, export licenses may be required for military or defense products, for products such as works of art, precious metals and jewels, antiques, raw materials or commodities that are available in only limited quantities, such as oil or scarce minerals or metals, and certain agricultural commodities or live animals. In Australia, the Department of Agriculture and Water Resources controls exports of agricultural products and assures our trading partners that Australian agricultural products meet certain import requirements. According to the department, efficient regulation of exports is the cornerstone of Australian reputation as an excellent source of reliable agricultural exports. If we take, for example, the meat industry, according to the department, meat export license for export of beef, sheep, or goat meat from Australia is required. You can find the particulars on how to obtain a license, the cost, and the assessment process on the department's website. So it's very valuable information in relation to the government regulations for the agribusiness sector exports. One key point I would like to make here is that it's very important not only to know the regulations relevant to your products, but also to keep with the updates, as these are subject to change from time to time. You need to do your research first before accepting sales offers from overseas, as there are many points you may need to address prior to accepting the offer. Some of these points you can see on the screen. One extra point to add is ensure your license conditions don't change, and if they do, address it accordingly. In relation to our point on obtaining the license before the contract, speak to RANDIP or to your international trade lawyer whether subject to receipt of all necessary export permissions or licenses clause can be included in your sales offer if you don't have your license on time. Now, let's quickly cover the export quota subject. The export quotas on export of a particular product are applicable predominantly for scarce or non-replaceable resources. It could be the case of a global quota, or country-specific quota per destination could be allocated. The free trade agreements are a good example for this. I will also give you an example for export quota. Australia has an export quota for wine. A wine producer has an advance quota dictating the volume of wine the producers are allowed to export in a given yearly trade cycle. Import licenses. Many countries have in place a system of import licenses for controlling imports, and the three most common systems of allocating licenses are first come, first served, license issued to historical importers, or license end user. If you're thinking of transferring your license to another party, check the regulations first whether you actually can do that. Please note that import quotas and import licenses allocation in many cases go hand in hand, as you require the import license prior to achieving the volume to meet the regulated quotas. For initial additional information on the topic of import licenses, just contact our office. We will redirect you to the right parties to speak to. Proof of origin is another key regulatory requirement. You may find that when exporting commodities overseas, on many occasions you'll be asked to provide proof of the goods country of origin. This is especially the case with the free trade agreements Australia has with other countries, where specific rules of origin are applicable. Without the documentary evidence of origin, such as the relevant certificate of origin, your importer will not be able to benefit from the reduced tariffs for your product applicable to the relevant FTA. And at the same time, you may not be able to clear customs at all, as the certificate of origin is a requirement of the free trade agreement in place. The rules of origin topics and the individual Australian FTAs and certification requirements will be covered in our next webinar, Export Documentation and Logistics, in detail. So I strongly recommend to attend this webinar. For now, what you need to know is that when it comes to the documentary evidence of origin, certificates of origin and certified declarations of origin are the two common types requested evidence by customs. We're talking overseas customs authorities. Certificate of Australian origin is a documentary evidence that the goods are originating from Australia, and the certified declaration of origin is a documentary evidence that the goods are originating from other country than Australia and then exported from Australia. Then the certified declaration of origin is applicable. For additional information or to obtain the relevant certificate of origin or certified declaration of origin when required for your shipment, just contact our office. When it comes to regulatory requirements, we have to mention the Incoterms. What is Incoterms, you may ask? The Incoterms rules are an international recognized standard and are used worldwide in international and domestic contracts for the sale of goods. The Incoterms rules have been incorporated in contract for the sale of goods worldwide and provide rules and guidance for importers, lawyers, transporters, and insurers. Each Incoterms rule specifies the obligation of each party. For example, who is responsible for transportation, for the import, and the custom clearance. By agreeing on the Incoterm rule in incorporating into sales contract, the buyer and the seller can achieve a precise understanding of what each party obligations are and where the responsibilities lies in event of loss, damage, or other mishap. The Incoterms rules are created and published by the International Chamber of Commerce and Industry and are revised from time to time. The last revision is Incoterms 2010, and the new revision, Incoterms 2020, will be available in the near future. We'll keep you posted on that one. There are 11 Incoterms rules. These are outlined on the screen. And for today, we're not going to be going in each individual one. We just don't have the time. Please click on the link on the screen, on the bottom of the screen, and you can see the definitions for each of these Incoterms. Why Incoterms, you may ask? Standards are required to define risk and obligations in international trade, and Incoterms are these standards. These are also commonly known as shipping terms. Who needs to know these standards? The exporters, the importers, traders, freight company, custom brokers, lawyers, banks, and anybody involved with international trade. And where you, the exporter, or your freight company can find the Incoterms definitions in the ICC Incoterms publication Incoterms 2010 booklet, there is also a wall chart. And I've already mentioned there'll be a new edition 2020 in the near future. If assistance is required with selecting the right Incoterm for your product export circumstances, please contact our office. Our experienced senior trade advisor will guide you accordingly. And this is a quick guide identified from my research on the topic today that gives an overview of buyer and seller obligations as per Incoterms 2010. I will conclude today's presentation with industry contacts that can assist you with your export venture. You then have to try to figure it out on your own because you're not on your own. Assistance is available. Contact our office for assistance. We can also liaise you with our colleagues from Austrade, Trade and Investment Queensland, Export Finance Insurance Corporation, and other strategic partners we work with to help you succeed internationally. Now I will hand it over to Randeep to discuss one critical topic to international trade, how to do your contracts.
Thank you very much, Diana. That was pretty useful to have a little refresher into all the regulations. Welcome everybody. And Diana, again, that was really good because you covered pretty much everything I can think of in regards to regulations at a very, very high level. Understanding your Incoterms and the allocation of responsibility is a huge, huge part of your contract drafting. However, your Incoterms are only as good as your contracts. So in this seminar, so if we just go to the next slide, here we go, this is it. So sorry, if you go back, Amanda, sorry about that. So we're just going to run through here the legal considerations in agency agreements. We're going to go through distribution agreements as well. The reason I focused on those two is really because as small exporters, those are really the two options available to you. But you also have direct sales agreements. So a lot of the principles that I'm going to be talking about would be common pitfalls in contract drafting and other legal considerations in international contracts are going to apply in that context as well. I'll also spend a little bit of time on international IP protection and how you can look after your confidential information as well. So Amanda, we just go through to the next slide. So talking about agency agreements themselves are very interesting and fraught with potential negative consequences if you don't get it right. The agent is incredibly important. They are going to make or break your reputation in any market. A poorly managed and monitored or compensated agent is going to ruin any opportunities that you would otherwise have in your market. So from a legal perspective, what can you do? What steps can you take? Well, if we're looking at agency agreements, you want to be thinking about the restrictions that you're going to impose on your agent. So what sort of controls do you want to have over your branding, your sales methods? What region can they sell in? Is their arrangement exclusive? Is it not? What products can they sell? Can they sell competitors' products? There's so many different rabbit holes that you can go down, but really thinking about those restrictions and what you want is going to save you a lot of time and a lot of heartache later on. If you enter into an agreement, and we've seen this where a client's come to us and said, oh, my agent's gone off and taken a competitor's product on board. And we said, well, hang on, let's have a look at the contract. And the contract allowed them to do that. So you need to make sure that you set that right from the outset and you manage expectations on both sides, both yours and the agent side. You also want to be thinking about the customers and whether or not they're going to be swayed by how much involvement your agent has or whether they might work directly with you. And all of that's going to depend completely on the product that you're planning on exporting or importing. The next big consideration will be the support that you provide to your agent. So do you want to have that marketing and management support? I say support, but what I'm actually talking about is being on top of your agent. So you use that support as a means to ensure that they're doing what you wanted them to do. So you're making sure that they are complying with all those restrictions. You make sure that they're getting the products out there in the right way. And a lot of that can be drafted into the contract, these support mechanisms, but you should also really think about those in detail. One important thing to think of with an agency agreement is a deemed permanent establishment in each country. So there's a possibility that if you're too involved with your agent, you as a company may actually have a deemed PE, a deemed permanent establishment in that other country. So that country will tax you on any income that you've then derived or should have derived from your involvement in that country. So that is a tax issue, but it's definitely something you want to make sure that you get clear in your agreement, and to ensure that you manage or avoid that risk completely. The next thing is really the commissions and monitoring. Again, monitoring I've already covered a little bit, but the commissions, making sure that those are commensurate with the things that you think are valuable as well. You want to be working those into the contract in a very specific way. You want to be doing it in a way that's not going to put too much pressure on your agent and allows them flexibility, but also if they're very successful, you want to make sure that you see some of that. So you want to make sure that it's flexible enough yet specific. So spend a fair bit of time thinking about how you intend to bring those commissions in, or allow your agent to take those commissions. At the end of the day, a lot of it boils down to risk allocation. So this is your Incoterms, essentially. Who's going to ship the product to the customer? Who's going to import it? Who's going to pay for transport? Who's responsible for what? Who's going to take out the insurance? Who's going to manage the product? And given an agent doesn't typically take title, if they do, it'll be flash title. So they'll have it one moment and then it'll be gone. How do you manage that? How do you put that into an agreement? All of that is really important. And you need to make sure that you spend some time, again, thinking about that when you're drafting these contracts. And that goes to the final point, which is contract characterization. You can call it an agency agreement. You can write throughout the document that it's an agency agreement. However, if the agent is taking title and you're heavily involved, it starts to look maybe like a distribution. So again, as much as you may have a characterization in your form of the contract, you have to make sure that the substance matches what you intend the relationship to be. So if we go to the next slide there, Amanda. Yep, so distribution agreements. Again, a lot of these considerations are very similar to the agency agreement, so I'm not going to run them through again, but a distribution agreement, again, that's going to be very important. Are you going to be able to get your product to people on time? Are you going to compensate them correctly? Have you managed them well enough so that it doesn't ruin your image in the market? You've got to think about, again, your restrictions. Do you allow them to promote competitors' products? How do you ensure that they are aligned with you as opposed to one of your competitors? Are your commissions commensurate? Are they performance-based? How do you want to do this? How do you intend your product to grow in the country? That's going to change how you draft those clauses in those contracts. Again, the support that you're providing to them, you want to protect your distribution channels, and support can be a really good way to do that. When I mean support, I mean just making sure that you're talking to your distributors about how you package your product before it gets to them, so you can help them out in many ways, and that may give you an edge over competition. Commissions, again, you tend to have a more difficult position arguing commissions with a distributor because they take legal title, therefore they would like a higher margin typically. So it's really about monitoring those commissions and making sure you've structured that in a clear and very specific way again. And that risk allocation, I can't even tell you how many times the Incoterms that have been used do not match up with a distribution agreement that I've seen. And I spend a lot of time telling clients, look, although they are your distributor, you've decided to use FOB Incoterms. So that's where the buyer is responsible effectively for shipping as opposed to CIF. However, the actual terms of the contract are CIF. So you need to pay up until the buyer's nearest port. So you've made an error in your drafting, and the distributor will try and get away with that. They will try to use the Incoterms you want to see, yet draft the substance of the contract in a completely different way. So think about your risk. Think about if you're pushing it onto the distributor or if you're keeping it and you have to pay for it. Do you have to take out that insurance that you don't want to take out? So really spend some time thinking about that. And again, that goes into that contract characterization. All right, next slide. Now, as I was drafting this for everybody, I was thinking, okay, maybe I should talk about some of the common pitfalls and things that I've seen go wrong. However, I think a more effective way to do this is really to give you guys some top tips for contracting. It's quite a maverick world, international trade at the moment, and that really seems to be because there's the issue of sovereignty wherever you go. There's an enforcement issue. There's no world police force, so people tend to draft whatever they like into a contract. So one of the key things that you can do to immediately improve your position is be the drafter, not the reviewer. Make sure you're the one who's in charge of understanding where the warranties are, where your indemnities are, and that the contract is fit for purpose. It's actually really easy to put those together. It's really simple. However, the hard part and the part that people come to us for are the parts that require expansion. So you can put together a very, very simple contract. However, is it set up in such a way that's going to enable you to grow within that market? And there are other considerations here, but that long-term consideration is a really, really big one. Where do you see your product in 5, 6, 7, 8 years? Is this contract going to do? And if it's not going to work out well, how do you, what should you be doing? How should you be amending your contract? One simple way is to have very short-term contracts. However, some distributors don't like that and they want to be locked into a longer-term contract. So that comes down to negotiating effectively. Again, I've said this a few times, but it's really important, making sure your substance equals your form and you're clear on who has the practical responsibility here, who's going to bear the responsibility for import clearance. A lot of what I'm saying to you, and I hope the theme that's coming across here is, where is my risk? Where are the insurances that I've got to put in place? Where are my regulatory compliance exposures? I want to be making sure that as much as possible, the risk is on the other party, and any risks or anything that I need to do, I know about. So having those warranties and indemnities as well will ensure that your contract reflects what you understand your relationship to be. Being specific, I've said that a little bit earlier on as well, but if you can be as detailed as possible when describing your product and as detailed as possible in describing exactly what you expect from the relationship, you're going to make sure that you're able to enforce those rights a lot easier, especially in foreign countries, in jurisdictions that you have never had any experience in, or if people are dealing in different languages, there's a miscommunication of any kind. With vague and open clauses, you're going to run into all sorts of issues. However, if you have very specific, detailed clauses, you can circumvent a lot of those issues before they even arise. And finally, that confidential information and intellectual property, I'm going to go into that in a little bit more detail later on, but people don't necessarily know what is confidential information. Something that you may think may add a lot of value to your business or your product, someone may not consider that to be confidential on the face of it. So you need to explicitly outline what's confidential. And that would be one of the cases where I would say have a broad brush approach. And we've got a few standard clauses that we would typically pop in there that have worked for us in the past. With your intellectual property, I don't know if a lot of you have had experience in this area, but you really should understand your difference between your trademarks, your copyright, and your patents, because each of those are protected and treated differently under international law. But I'll go through those on the next couple of slides. So some other key drafting considerations for you are jurisdiction. You want to be fighting on home turf. If you've ever had a look at one of your, maybe your airplane tickets, if you've ever bought one, have a look at the jurisdiction that you would, that the contract is subject to, and you may be surprised that you actually have to fly somewhere like the States, as opposed to, like, if you're dealing with Singapore Airlines, you may not actually have to go to Singapore to enforce your rights, but you may have to go to Vietnam, you may have to go to the US, you may have to go over to London. That's really because a lot of these companies have drafted these jurisdiction clauses into their contracts because of where their legal team is based or where the legal system is most favorable to them. So make sure that you've had a little bit of time thinking about that jurisdiction, and if you're not in control of the drafting of the contract, just make sure you're able to actually go over and enforce the your rights in that other country. Now, a very simple way to get around it is a lot of contracts will say you submit to the exclusive jurisdiction of New South Wales or Australia. You can simply change that to non-exclusive as opposed to exclusive. So there are ways, again, in the negotiation. That's where it's useful to engage someone like me to have a look at the contract, point out where some of your key issues are, and help you to negotiate those terms. Termination, make sure you understand how you're able to terminate, how the other party can terminate, how they can vary, how you're allowed to vary. Do you want to vary the contract? Do you want to have that flexibility in there? Again, with the term, what is having a fixed term give you? Does it give you certainty, or would you prefer to have it flexible? When is the effective date? Is it going to be subject to certain conditions? Those are things that you really need to think about, and you need to think about them in your particular context. So you may actually want a situation where you're able to easily terminate an agreement because the market's performed a lot better than you thought it ever could. Or you may be in a situation where you want to make it very, very difficult for a particular distributor to get out of your contract or your agreement that you have with them, because you want them to be your exclusive distributor for years to come. Title, you got to ensure that the title is transferred when you want it transferred. Do you want to retain title up until it's actually handed over to the customer, and therefore you've got recourse to pull all of your products back if you wanted to? Or do you want to have title only up to the factory floor, and then beyond that point, they take control over, the distributor or the agent takes control over the product from that point? That'll be sort of an ex-works contract. Again, it all depends on circumstances. You've just got to make sure it aligns with what you want. The payment clause, I was actually debating talking about this because I could talk about that for a while, but payment clauses can go horribly wrong, especially when dealing with somewhere like China. They'll give you an amount and then say, oh, sorry, we thought the currency was in renminbi. And you're like, well, obviously not. It was in Australian dollars. And they said, well, where is that in the contract? So we've had to amend several contracts just for that basic adjustment. But you got to think about the consequences of late payment. What are your discounts for early payment? What are the bonuses? How does the bonus structure work? Again, it's something that I could talk about for days, but I will not bore you all. Parties involved, that may seem very, very simple to you. However, it is not necessarily the most straightforward thing in the world. When deciding which party should sign the contract, you need to be thinking about who do you want recourse against if everything goes wrong. If a person signs the contract, does that help you? Or do you actually want the company that you're engaging with to be held liable? So do you want the director to sign it in their personal capacity? Probably not. You'll want the company to sign it. So putting in the correct execution clauses, making sure that the right parties are addressed and involved. If there are third parties involved, where you've got a freight forwarding agent, who manages the risk there? How do you work that into your contract? Do you join them as a third party to the agreement? There's a potential that you would. Well, maybe it makes sense to create a new contract. Again, it's all fact dependent, but it should be something that you definitely think about. Then with the actual delivery, you've got to think about, again, the insurance and export clearance and the risk transfer, how the goods are going to be delivered. So that's more of a practical consideration, but again, one that you should definitely think about, because a lot of customers may come to you and say, well, you didn't deliver it to me the way that I expected, and therefore I didn't collect it, or therefore I'm not responsible for the damage that was done. One very simple example is if in the contract you were required to box and package the item in a certain way, you didn't do it, you let them take it, they then took it, imported it into the country and gave it to the customer files a complaint because the product was damaged. Who is the customer going to go after? Maybe the agent, maybe the distributor, but then at the end of the day, who was ultimately responsible for that? That may be you, because you breached the packaging requirements in the contract that you had with your distributor or agent. International law considerations. It is a spaghetti bowl of agreements, compliance, classification, valuation, antitrust law, accounting law, IP law. It's an absolute mess. So you need to sit back and have an expert have a look at your contract and see whether or not you've drafted this the right way to be in line with all of those international law considerations. One very simple example, which I believe Diana touched on, were dual-use items. So that's an item that you may not consider to be a military weapon, but actually can be classified as such as very, very high strength of rope. So if it is deemed to be a dual-use item, you'll face all sorts of export compliance issues here in Australia. So making sure that you've turned your mind to those or had someone have a look at the contract, even very briefly, is worth its weight in gold and can keep you out of a massive fine or, even worse, a prison sentence. So if we go to the next slide, just very, very briefly on international intellectual property protection. Trademarks, copyrights, patents, please understand the difference between all three. I've seen it go wrong where people don't understand it. Just to outline it very briefly to all of you, a trademark is an image, a logo, a slogan, a color. Recently it's been smells. You could trademark a smell. A copyright, that's more aimed at your literary or artistic works. So that's books, videos, sculptures, photographs, prints, television, and so on. It's more the expression of an idea, while some patent is really the idea itself. Now, if we look at the protection of trademarks, right? So again, we're talking about your logos and your slogans and so on. In Australia, you can register them for 10 years. You'll officially have to register it with IP Australia, and they'll need to be approved by IP Australia. Now, it's all well and good. That protects you here in Australia. That's fine. However, what happens when you go overseas? How do you protect it on an international basis? Well, you have this thing. Well, essentially, you have two options. You can either do this on a country-by-country basis. So you go to each country that you plan on exporting your product to, and you register the trademark in each country. Good on you if you have the time, the effort, and the energy to do that. However, it is a very time-consuming process. The way I would recommend you do this is via international registration through the Madrid Protocol. So that allows you to make an international registration of a trademark at the same time as your registration here in Australia. So IP Australia is very good. They have a few very good guidance documents and a few really good links that provide you with everything you need to know about how to apply through that WIPO process. So that's the WIPO process being the World Intellectual Property Organization, and how you do that all at once. So if you are planning on taking your product international and you haven't trademarked your product yet, do it in Australia, but make sure you do that in line with the Madrid Protocol. if we go to copyrights, copyrights are, again, very, can be a little bit difficult to register as such. It's more about enforcement. So copywriting in Australia doesn't actually need to be done. You're automatically protected as soon as you display to someone that this book is subject to copyright. That's enough. However, you need to think about when you go overseas, is every other country going to take the same approach, or does every other country have similar protections? Now, there's no such thing as international copyright law. There was the Berne Convention for a while, which allowed protection of literary and artistic works. Then there was the Universal Copyright Convention. However, now we have a thing called TRIPS. So that's the International Trademark Protection and Enforcement tool that everyone who's a member of the WTO will use and rely upon to provide copyright protection internationally. The terms of the TRIPS agreement essentially requires each country who is a member of the WTO to have legislation in place in country that is very similar to Australia's, right? So the issue that you have is not so much, oh, well, my copyright's legally protected in that country, so I'm fine. The issue you really have is enforcing it. So going over to China and saying, hello, sorry, excuse me, this copyright has been infringed, actually getting them to wake up and do something about it is going to be the hard thing to do, and that's where you rely on contacts. I've got a few people that I use in country. You've got to really find that contact who you can rely upon and who's connected as well and can get things done. Finally, with patents, that's essentially your legally enforceable right to for advice, substance, method, process, and idea. In Australia, we've got two very, they've worded this very interestingly, and I don't know if I agree with the way they've classified it, but you have a inventive and an innovative patent. So in order to be innovative, it has to be new and useful. It's got to be really out of the box. So that's your not so much a innovative, like not so much a incremental advance in technology, but really a groundbreaking advance. And then you've got your standard patents as well. Again, the issue that you have is enforcing it internationally. It really depends on which country you're going into. You can go on a country-by-country basis, or you can do a PCT application, which is the Patent Cooperation Treaty application, which again is administered by the World Intellectual Property Organization, that allows for automatic registration in 152 countries. It's very it's a very time-consuming process, and then it takes a while for it to actually be registered. But once it's done, it's done in each of those countries. So it does effectively save you a lot of time. Again, that's something that IP Australia will help you with, and they'll hold your hand through. But again, it's something that can be time-consuming if you get it wrong. Now, I've said there, beware the elephant in the room, and I've touched on it. But the elephant in the room with any international law issue really is sovereignty. So who is going to enforce your trademark breaches? Who's going to sit there on the ground and remove that Louis Vuitton bag from the market? The approach that's been taken internationally is patchy, it's inconsistent, it's unreliable until it tends to be one of the big boys making some noise. The best thing that you can do is to put in a tailor-made IP protection strategy, and that's what we do. Here at DWF, we can provide you with practical solutions. We can have a look at your entire supply chain and see whether or not you can fragment it and then assemble it yourself somewhere. Is there a way that you can head over occasionally to some of your big distributors and see where their products are actually going? Can you do this in an incognito manner? Or do you want to go in making a lot of noise and making sure that people there are aware that you're looking at them and you're going to be watching them with a very, very close eye? So I've said there that I'll talk about China very specifically, but very, very briefly, China has a first-to-file trademark registration system, so it doesn't matter if someone else has been using it, you've got to file it first. However, the exception to that is where filing's been made by someone in bad faith. We can seek legal advice. We have counsel there that we use quite often. You can even do this from Australia through the Chinese Trademarks Office. Australia and China have a very special relationship. So getting that in place before you actually send your product off to China is what I would recommend you do and spend a fair bit of time on. If you just go to the next slide, you'll see there that I've included 2 brochures. One's our international trade brochure, which if you double click on, it will open up that brochure for you, and our trademark protection and commercialization brochure. And we have a IP team here that stands willing to help you with any IP issues you may have. So I hope that's helpful.
Excellent. Thank you very, very much, Randeep. A lot of great information. I'm even having people comment saying that this has been very valuable for them. So thank you very much. Okay, I'm conscious of the time. We've just got a few quick questions to run through. First one for you, Diana. Can I obtain the Incoterms 2010 book from CCIQ?
Yes, that's not going to be a problem at all. We can purchase the book for you on the International Chamber of Commerce in Paris, and you can collect it from our office, or we can send it in the mail, whatever way you want to be distributed to you. The only thing I have to warn you, because it's coming from Paris, and they usually ship them, so it could take up to 4 weeks to get here. But we can order the book, we can order the organization, the Incoterms chart as well. And if you have the time one day, have a look at the ICC actually website. You will find there a lot of ICC books which you can be able to use in your everyday business as well. So we can order them for you from here. That's not a problem.
Okay, and what happens if my goods are held by customs?
It really depends the reason. That's the very first thing we'll do, is ask you what is the official reason the customs officials are actually holding the goods in customs. If it is a matter of certificate of origin, which is the documentary evidence, non-compliance, then we have an official protocol in place with the Australian Chamber of Commerce. We're going to ask you the official reason from customs, the port of rejection, the name of the customs officer who actually rejected. And then this information is going to be going to the Australian Chamber of Commerce, then to the Department of Foreign Affairs of Trade. And the department is going to collaborate with their counterparts in market and investigate the matter on customs level. So basically, your cargo is going to be released. If the matter is something else, then we have to see what this something else may be. Just recently, we had a situation when a government representation was required in Hong Kong at customs, and we were very, very happy that both the Austrian Trade Commissioner and Trade Investment Commissioner actually were happy to assist and help our member at customs. So it's really depends on the issue, but the best way to go about it, tell us what the problem is, and we'll get to the bottom of it and try to find a solution for you.
Okay, and just a quick question for you, Randeep. Do you have any practical implementation on the theory that you've provided today, on what you've come across and how you've gotten around it?
Yeah, absolutely. I mean, it's really, I think I've touched on it throughout the presentation, but really it's about sitting down and making sure that the regulations and the way that the customs officials are enforcing a lot of the regulations match up with your contracts as well. So one example is when you're importing wine or alcohol into places like China or Malaysia, there is a requirement to send nothing but alcohol in that shipping container. So that can be a bit of an issue. So you got to make sure that you work with others in the area or talk to a consolidator to try and get your products into the country.
Excellent. Okay, I think that's all we have time for today. Thank you so much, Randeep, for presenting today, and thank you also to Diana and everyone who's joined us for today. We will send out an email later on that has a copy of your copy of the recording and the webinar slides, and we'll also have some links to some other resources that were mentioned, as well as links to our final 2 webinars in the series, which is Export Logistics and Documentation on June 13, and Getting Paid Export Support and Resources on June 27. So we'll send that all out to you later today. Thank you very much for joining us, and on behalf of CCIQ, enjoy the rest of your day. Thank you.